On behalf of the Utah Medical Association, I'd like to welcome you to this evening's program. We're grateful for the Old Mill Golf Course in providing this venue for us. I'd like to also express my appreciation to Michelle McComber and her excellent staff in getting this program together. And also like to thank our speakers who will be speaking to us today. I'd also like to thank all of you for the great service you provide to the physicians and patients in the Utah state and also in your this neighborhood and in this area. Physician-led healthcare. Physician-led healthcare is a very key point that needs to be emphasized as we proceed with the Affordable Care Act. And we're excited for this evening's program. And I appreciate you as leaders of physicians and leaders in your community for being here. I know that there are still people coming and the food will be there all evening. You're welcome to go back and get some more, get some drinks as we go through this. There's a couple points that you need to understand. At your table, there is a questionnaire that we would like you to fill out. We would also like you to give us any feedback. When there's going to be over 100 people here, we're not going to have time to hear from everybody, but we would like to hear from everybody. And if you could give us some feedback in written form, or you can give us some feedback in email form. If you get on the Utah Medical Association website, there will be a link there where you can send some of your comments, questions, concerns after tonight's program. You can send them directly to my email there, which is pres, P-R-E-S, @utahmed.org. And I'd love to hear from all of you. And please take the time to email or write down some comments. This yellow sheet, there's also plenty of room and space to write some other things down on there. Be sure and turn it in. If you're interested in serving on a task force to help us with some of these things that we will be discussing tonight, please put your name on it. When we do open it up for some questions and comments, we're going to limit it to just 1 minute at a time, and there will only be a short time, so we would like to have you write down some of your questions either on the notepads that are at the tables or on those 3x5 cards that were passed to you, and we will be collecting those as soon as the question time starts after Mr. Sandack speaks to us. It is my pleasure to introduce to you, to start our program, Mr. Arthur Sandack. It's amazing how life brings people together that happen to know each other from years past. Art and I had two daughters who played soccer together over 12 years ago. And we had a wonderful time on the sidelines talking to each other. I know him as a father. I know him as a runner in the mountains above the University of Utah. I remember him showing up at a soccer game one time covered in mud. He said the trail was really muddy and he slipped and fell and he had mud all up and down him. And Art didn't stop Art. He was right there supporting his daughter. He's a father of 3 children, lives in downtown Salt Lake City. I think you've lived in Salt Lake City your whole life, haven't you, Art? Born and raised in Salt Lake City, he graduated from the University of Utah Law School in 1976, has been a solo practitioner ever since. He's represented national and local labor organizations in their efforts to obtain collective bargaining rights for the employees they represent, to negotiate fair contracts with employers, and to enforce those agreements before federal courts and regulatory agencies, as well as in arbitration. He's the past chair of the Labor and Employment Law section of the Utah State Bar, and he also represents employees injured in the course of their employment and has served on the Utah Labor Commission Workmen's Compensation Advisory Council. Please welcome Mr. Art Sandack.
Sorry. Do you want me to wear this? Oh, you're supposed to wear this too. Okay. Okay. Want me to carry that?
Just pop it in your pocket.
Oh, okay. And then speak into this as well.
Speak into that for today.
Okay, great. Well, good evening. It's a pleasure to be here. I want to thank Michelle and the association for engaging me to come tonight. I understand you want to know about unions, which is rather unusual because usually nobody wants to know about unions. They've obviously gotten a bad rap and been demonized over the years, but I've got a lot of good things to say about unions, obviously. I mean, I get my bread and butter from them, but I truly believe in the benefits they have to offer to people, to workers, and to society as well. Just a little bit more about me, because if you make small talk with people, they ask you what you do for a living, a common discourse, and well, I'm a lawyer. What kind of a lawyer are you? And I say, well, I'm a union lawyer. And that just pretty much brings the conversation to a stop. You get the common response to that is there are unions in Utah. And yes, there are unions in Utah. There aren't a lot of union lawyers in Utah. There's maybe one other guy who represents unions in the private sector, which is what I do. He represents the Teamsters. And I've represented a good number of unions, the United Steelworkers, which is probably one of the biggest unions in the country, and the electrical workers. They represent the employees of Rocky Mountain Power. You get into these different situations. So like a union like the electrical workers, they represent a lot of people, or maybe 2,000 people, type of wall-to-wall type of organizations throughout three states, where you're talking about representing employees who in maintenance and operations of their power plants. You're talking about their people in power delivery that put the transmission and lines up that kind of run from the substations to your home, and then there's customer service people and all kinds of people representing like the employees out at Kennecott who work in operations and maintenance in the refineries and the concentrators, and the smelters out there, representing oil and chemical workers in the refineries such as Chevron, people who work extremely hard, long days in hazardous employment. And some of the atomic workers up at the INL in Idaho who do the same thing, only they work with nuclear energy and research. And for the most part, the organizations themselves are all affiliated with a national organization, and they have chartered locals. And they, for the most part, they're all working on the clock. They all have day jobs. And they step up and they get themselves elected to be the president or business agent or manager of the local. And a lot of that they just do on their own, time after hours. And it's hard. It's very difficult. And they're not highly educated, but they're highly skilled and they're smart. And they're devoted, but it's a difficult thing for them because the companies, for the most part, you're talking about a company such as Chevron with immense resources and abilities to control information and all the advantages that they have, and they've got to carry on the fight, and they do a good job of it. They can't always afford a lawyer, and that's one good thing about unions. They, to a large extent, once they're established, you can really take care of your business without necessarily having a lawyer there. And we'll go through that, but I just want to give you an idea of essentially the areas that I practice in. I obviously haven't practiced and represented employees of, unions who represent employees of healthcare institutions because, frankly, there hasn't been a lot of organizations. I know that the nurses have been trying to get established here in Utah and have had a tough go of it, but obviously I'm not aware of any physician unions. But times seem to be a-changing, so I welcome your interest in this thing because I think it bears a lot of consideration. So what I want to talk about is, the ability of doctors to organize and into a union, and the pros and cons of doing that, and then how you go about it and what you need to do. First, I want to give a kind of a brief overview of federal statutory laws and regulations of unions and what this is all about. In the private sector, the National Labor Relations Act essentially establishes for employees protected rights to form, to join, or to assist a labor organization and to bargain collectively. And then also the employees have a right to refrain from doing that as well. There are certain rights under the law that you don't need a union for that are still protected. Then you could seek redress with the National Labor Relations Board by filing unfair labor practice charges because it protects all employees' rights to concerted activity. And concerted activity is when two or more employees take action for their mutual aid and protection regarding the terms and conditions of employment. The single employee may also engage in protected concerted activity if he or she is acting on the authority of other employees. So you don't really need, in all cases, a formal organization, but obviously that's what you need to get anywhere, to, as Steve says, get on a level playing field if possible and negotiate with employers. The federal law, National Labor Relations Act, has some special provisions with regard to healthcare institutions. Prior to 1974, nonprofit hospitals and institutions were not covered under the Act, but in 1974 they were. And they added some other provisions that provide for more stringent notification when contracts are being either terminated and renegotiated or modified. And those are notifications that you have to give to the Federal Mediation and Conciliation Service that have to be given before any strike or lockout could occur. And obviously, the subject of strikes in healthcare is a very sensitive subject, so they've tightened that up. But the right is, you still have the right to do it. Now, the Landrum-Griffin Act is another piece of legislation that regulates essentially the internal governance of unions. And you'll find, because of these regulations, that unions are one of the most highly democratic organizations in the country. The officers must be elected by a secret ballot election. The Department of Labor keeps an eye on that thing. They need to file certain forms, essentially accounting for their revenue and their expenses. They're protecting and regulating the use of union funds for the benefit of the memberships and their mission. That there's a Bill of Rights for members in terms of addressing their free speech rights within the organization, their right to vote, and from time to time, with organizations as diverse and with separate interests, they're political. I mean, they have to have elections every few years to elect new officers of the union. And, some things can get a little gnarly there, but they function. And sometimes members are disciplined if they don't pay their dues or violate some of the internal rules that don't have anything to do with employment per se, and the disciplinary procedures you have to provide a hearing and notice and due process requirements and for appeals and that thing. So the Landrum-Griffin Act regulates the internal administration of the union. Under the National Labor Relations Act, employers are prohibited from interfering or dominating the administration or organization of the union itself. Employers are prohibited from interfering with employees exercising their Section 7 rights to form, to join or assist labor organizations. Employers are required to bargain, and if they refuse to bargain, an unfair labor practice can be filed with the National Labor Relations Board in the appropriate region. And of course, bargaining is never an easy thing to do, and we'll talk about that a little bit later. But that's the name of the game. You want to be able to bargain and make proposals and address your interests. There's certain bargaining subjects that are mandatory, such as wages, hours of work, and other conditions of employment. There are certain permissive bargaining subjects that the parties don't have to bargain about but can. And then there's illegal bargaining subjects which are prohibited. The National Labor Relations Board is responsible for essentially certifying the bargaining unit and holding a special election, a secret ballot election, to determine among the classified employees who belong to that bargaining unit if they, I think I lost my sound here. There we go, sorry. the majority supports and wants a union to represent them. So that's just an overview of the laws. Let's talk about doctors forming and joining, being represented by a labor organization. They can do it if they're employees. And in certain respects, you think, well, how hard of a decision is it to determine if someone is an employee or not? There's certain obvious indicia of employment. They work. They're paid by the hour. Their FICA withholding is made. They're given W-2 forms, things of that nature. Obviously, those are employees. But arrangements are sometimes made in business with independent contractors. And if they're truly independent contractors, they're not employees. So you see that issue coming up in healthcare with HMOs and some of the contracts that they have with providers that will come right out and say this is not a contract of employment, this is an independent contractor, but that's not necessarily the final word in the matter. And those matters have obviously been litigated, and I'll talk about that. You might have heard about the Amera Health case in New Jersey. In 1999, that was an HMO, and the United Food and Commercial Workers represented the employees, and they sought to represent the physicians there who basically were part of a network and did the work for contracted with the HMO. In that situation, the doctors pretty much had their own facilities, and that's where the patients were referred to. And but there was the real test with independent contractor, and what was before the National Labor Relations Board there was the right of the HMO to control the doctor's services and the access the doctors had to the patients. And in that situation, of course, the doctors did not just exclusively work for that HMO. There were some other PPOs and HMOs in the area, but they had to agree to take on so many patients and provide the services. But there was the regulation, I'm sure, that you're all familiar with in terms of credentials, in terms of quality assurance, and all kinds of things that probably drive you all crazy on a daily basis. But it was basically they were paid for, it was the fee-for-service type arrangements. And the board, in that case, found that the doctors, although they were controlled to a large extent, they also were not that closely monitored by the HMO, and they had access, they had some ability to negotiate with the HMO the terms of the contract, and a number of things that went into it. So it was determined there that they were not employees. But since then, obviously, there have been cases and efforts where the physicians have been able to show, in fact, that they are not independent contractors, are truly employees under law, as defined broadly by the National Labor Relations Act and the common law of old common law notions of master servant. So every situation has to be closely scrutinized, and obviously a lot of work goes into that. I mean, I think in that New Jersey case, the hearing went on for 14 days But it was somewhat a first-time precedent type case going forward, so it was obviously carefully presented. Other employees, obviously big issues arise out of whether the employee is a managerial employee or a supervisory employee, in which case they cannot be represented by a labor organization. And you get into big questions about that. Some of the questions are easy to determine, whether the employee has the right to hire or fire and discipline, things of that nature. But there's more dicey issues that come up about the ability to responsibly direct others. And the Senate has looked at this thing, and the board has tried to address it and say, well, it's, when they're directing others in the treatment and care of a patient, that's different than directing others in the interest of an employer. So they've tried to open up the door that way, and there's a lot of contention about that type of thing. But in the classic case, there may well be a lot of you in here in this room, I don't know, that are unquestionably employees. And there's been inroads made over the years. Also in 1999, in Boston, a union was formed and successfully was able to be certified by the board for residents and interns and hospital staff. And that was a big, important case. The American Medical Association, California Medical Association, all kinds of associations kind of by amicus curiae weighed in on the issues, and it was held that they were not students, that in fact they were employees and entitled to representation and entitled to bargain collectively. And of course you're all probably familiar with the recent decision by the regional director involving the football players at Northwestern. So what did they do? This thing's been building for a while, but basically the quarterback of the team kind of took the lead, and they formed what they call the College Athletes Player Association, and they took this issue on. Now they were supported by the United Steelworkers in that, but they were given support, but they were not really formally affiliated with the Steelworkers or paying dues to the Steelworkers, but they obviously needed the support, the financial assistance, and the legal expertise and knowledge and how to approach these things to proceed. But if you look at what these student athletes are, they're not. These people are not brought on the football team and given a 4-year scholarship, which is quite substantial compensation because of their academic prowess, but because of their athletic prowess, and I don't think it takes much to imagine how controlled they really are by the university itself in terms of when they report for training camp and when they go to bed at night and when they get on the bus and what films. To my way of thinking, it's like a no-brainer. They really are employees. And of course that case has got a long ways to go, and it's been a long time coming. It's such a great social shift, but I think its day's come. So in that case will be appealed to the National Labor Relations Board itself, and then more likely wind up in the federal courts. where the federal courts will decide whether the board properly exercised its discretion and jurisdiction in deciding the case, and who knows, it could go to the Supreme Court. So that's basically the requirement, that you need to be an employee. And if you are, and you're not a temporary worker or these other categories that I've mentioned, you can organize and begin this journey towards bargaining with your employers. So what are some of the pros and cons of a union? You know, if you're certified to represent the employees, then the employer has a duty to bargain in good faith with the union as to wages, hours, and other conditions of employment. And I've mentioned briefly the different types of bargaining subjects. So having the right to bargain is a valuable thing. It doesn't get you a contract, obviously. The law does not require an employer to make any concessions at all in the bargaining. It requires good faith bargaining, that you meet and confer reasonable times and places and address the issues. And you would expect to see in the bargaining that there would be some concessions and movement towards one another, and obviously contracts are bargained successfully all the time. If you're unable to negotiate an agreement, then you get into the situation where you would might have to resort to economic action, which is the strike, or the employer would have the right to lock out the employees, and but hopefully it wouldn't come to that. No one would want to see that. And you know, as employers and employees establish long collective bargaining relationships, you see less and less. You don't see that many strikes. Particularly, you know, these days, it just doesn't seem like that. You see it, but it takes a long time, obviously, to get there. The other benefits of unionization is basically operating under these federal laws. The federal laws preempt state laws and state regulations, not entirely, but to a large extent, when the activities are protected or arguably protected by the federal law, such as striking. So the types of places where you wouldn't bring up the law is when the state has a traditional interest, such as in preserving the peace and safety of the public. But federal preemption essentially is very helpful in getting over some of the local politics that you might have to face. I mentioned you don't necessarily need a lawyer once you get established and down the road, but I would think if you were going to proceed and to actively try to get established and certified as the representative of a certain group of employees, and as you build those organizations, that you'll want either the help of a lawyer or another labor organization, established labor organization that you might consider affiliating with. And there's more and more of them that are stepping up, that are out there. I'm frankly not aware of them in Utah, but I mentioned the United food and commercial workers. A big union is the Service Employees International Union, which is not affiliated with the AFL-CIO. And it claims to be the largest healthcare union in the country. And it's apparently has merged several physicians' unions together and represented them successfully. So you'd want their expertise, you'd want their wallet behind you, you'd want their solidarity with other organizations and their experience. And as I understand it, the AMA even has, in some form or fashion, sponsored the union. I was looking at something. Let's see here. The one article discussed the Service Employees International announced a merger of 3 previously independent unions, the Doctors' Council, the United Salaried Physicians and Dentists, and Committee of Interns and Residents, that's the CIR, that's that group in Boston. And they've created 15,000 member National Doctor Alliance, an entity with $1 million, this article was written some time ago, but $1 million annual organizing budget. And apparently the AMA has also voted to form independent union called the Physicians for Responsible Negotiations, PRN, maybe you've heard of. So there are experienced labor organizations out there. I did read one thing that the AMA was concerned about affiliating with some of them, that there's worried about sympathy strikes and things of that nature that might interfere with patient care. But, I think you cross a lot of these bridges when you come to it, and there's certainly ways, responsible ways to deal with it. The other pros are what you might be aware of, which is concerns about antitrust restrictions prohibiting combinations of business entities from restraining trade. So if you're a labor organization and you're representing employees in dealing with employers, you are exempt from those antitrust regulations. And that's a big thing. Now that doesn't mean that you'll be dealing with insurance companies, which maybe you want to be dealing with too, but you'll be dealing with employers, and obviously they have concerns about insurance company, but I would think the concerns are fairly mutual in cost savings and compensation as far as that's concerned. But that's a big plus. Some of the cons aren't really cons. I've already mentioned the federal regulations of internal union governance, and I don't really see that as a con. I think that's a plus. And you've got integrity, you've got officers that have to abide by the laws, and you've got reporting and due process rights and things of that nature. You'll need to have a constitution and bylaws. All unions have to have governing documents. But when you affiliate with a national or international organization, those things kind of are set up. And when they charter the local. And obviously in Utah, it's more difficult to organize I guess you could say it's a con, because Utah's a right to work state. And that is a very misunderstood term. Basically, a misnomer. I don't know what it has to do with the right to work, but it basically provides that a state can, if a state chooses, it can have the right to work laws, which mean that in order to work for an employer, you do not have to join the union that is certified bargaining representative. So these people get what they call free rides, where the union represents them. It has a duty to represent them, such as if they're, say, terminated. Most union contracts provide for that an employee cannot be terminated without just cause. And that's just an extremely valuable right, because most employees can be terminated at will for no reason, for the wrong reason, for a bad reason, as long as it's not an illegal reason. So you do have that, but it builds solidarity, and the people that join that union and local want to belong to that organization, and they do it. So I guess I'm running short on time, but I've suggested how you go about it then. I think it's obviously a step-by-step process, identifying employers with, perhaps you start small with smaller groups of employees that you can get experience and start building the membership. And you petition the board for to be certified. You don't always have to do that. The law also allows for employers to recognize you without an election. But basically you need to have at least 30% of the support authorizing the union to represent you to get to the board and to hold that election and proceed. So I guess with that, we'll turn it over to whatever questions you got.
I don't know if this mobile one works. Can you hear me as well?
You just have to really go close.
Yeah.
Oh, okay, good. Up and down.
Yeah, like that.
Okay, a couple of thoughts. First, tonight we're just presenting things that are going on across the country. Obviously, the Utah Medical Association is not sponsoring any of these statements that are being made, but we hope to inform you of things that are going on in other states. There are other states exploring the possibility of unions. As you probably figured out, it is only for physicians who are employees, and the physicians who are employees can organize to help themselves in their negotiations. A couple other points before 7 o'clock. 7 o'clock is when we need to move on to our next next speaker. There is a PAC form, UMPAC, where you can donate to UMPAC, which is our Political Action Committee, who helps us with our negotiations with our legislatures here in the state and also our congressmen. I'll say that the Utah Medical Association has great clout with our congressmen because of UMPAC. We were able to visit with all of our senators and congressmen in March and have a good impact on the things that they were considering, which included SGR and including ICD 9 with ICD 10 repeal. And I would encourage you to donate to UMPAC tonight to help with that political action committee. With that, are there any questions that we could ask Mr. Sandack in the next slide?
Do you want this?
Oh, he has one. Mr. Sandack, would you go ahead and read that question and then answer it?
So this says, if physicians formed a union, would it be considered ethical to engage in a work stoppage the AMA would consider that unethical if patients were put at risk. And, you know, in preparing for this evening's presentation, I became aware of that position by the AMA. You know, it's obviously a difficult question, but there, you know, some of the opposing arguments that I saw were, well, you know, we are trying to provide good patient care here. Obviously, that's your duty and obligation, and to a certain extent, you feel like you've been put in a position where the interference with the patient care comes from the employer. You have a residents working untenably long hours, for example, and patient care suffers. There was, I was trying to find the reference that I found to it. There was one situation, I think it involved the nurses, and there's more history with the nurses, but they're obviously engaged in patient care, and I think it came down to whether the strike would be illegal because it would interfere with patient care, and the court was asked to enjoin that, and basically said, well, no, this is where this federal preemption comes in. That they have the right to strike, and there's all kinds of situations where strikes threaten the safety and well-being of people. I realize it may not be as intimate and as direct as the situations you have, but I wouldn't, you know, I think you've got to. The strike is a valuable weapon. It's always used cautiously, and before it ever would, you'd take a hard look at that. But I don't think that would stop you from, if you wanted to, proceeding to organize and obtain collective bargaining rights and pursue it. You know, if the employer bargains in bad faith, and I mean, a lot of the challenges are, and you're really going to be in a fight with some of these bigger institutions, and some of them don't really care what the law is, and you can file all the unfair labor practices you want, and it can be tied up for years, but in the meantime, people lose their jobs, and we're not going to bargain. So you get into those situations, but I would think that the medical institution itself has an obligation, and if they push things to a certain extent. There's such a thing as economic strikes, and there are also unfair labor practice strikes. If you're engaged in a lawful unfair labor practice strike, when it's resolved, you have the right to your job back. Economic strikes, they do have a right to replace the employees. Is there another question?
I have another anonymous one. Does anybody want to ask one from the audience?
This is, can the Utah Teachers Union be a model? And inquires about the definition of an employee. It seems to, there's questions about being employed by your own corporation or paid by insurers, and can we be considered employees of insurance companies? No, you're not employees of insurance companies. Now, maybe that if the insurance company owns an HMO or something of that nature, then yeah, maybe you're employees of the insurance company. But you know, they have all kinds of political or business entities that they set up. As a general rule, the teachers in Utah is a good example because they don't have, they're public employees and they have no collective bargaining rights in Utah, but there they are. They've got an effective organization, and they do bargain contracts consensually with the school districts, and they've got some real political heft as well. And it's, you know, it's essentially an example of, in spite of the laws not always aiding you, it doesn't necessarily stop you either. They made legal arrangements. But as a general principle, political entities of the state or the state itself are exempt from the National Labor Relations Act. Now, where the University of Utah medical facility fits in that, obviously not evaluated, but it isn't necessarily, you know, they could well be covered by the act depending on how they're managed.
Mr. Sandack, my name is Bill Hamilton. I'm an anesthesiologist here in Salt Lake. And I was a delegate to the AMA when we discussed this issue about 10 years ago. And you're right, we did form an organization called PRN, Physicians for Responsible Negotiation. Now, we debated for days as to whether or not it was a union or just a negotiating entity. I don't think we ever settled that. But we had two problems, as I see it. One you've identified is it only applied to employees. And the other problem we had was, actually, that was my question that you read the first time, is the ethical considerations around the work stoppage. Particularly if we joined with other unions, let's say like the machinists go on strike and so the pilots won't cross the picket line. We didn't want to be in that type of a situation. The other problem is the ethical duty that we have to our patients. I don't think you can find physicians that for even economic reasons or unfair labor practices refuse to come into the hospital to see a sick patient. That's just unethical. It's in the AMA Code on Medical Ethics, or their opinions that engaging in a work stoppage that would potentially harm patients is considered unethical behavior. And so for those reasons, even though the AMA passed that, PRN didn't go anywhere. And I think we would face the same issues here if we were to try the same thing. Any comments on that issue?
Well, I've tried to speak to it as best I could. One thing I didn't mention was the board has had some concerns in the healthcare industry about the proliferation of too many labor organizations, but basically rested on the determination that as professionals, the physicians, the appropriate bargaining unit for physicians would pretty much just be physicians. I'm not saying that you couldn't also affiliate with nurses or other groups, but going into it, you're probably looking at a bargaining unit that just includes physicians. Are there any more questions?
If there are more questions, please give them to us. Mr. Sandack's going to stay during our next presentation, and we can still have him answer some questions. So please write them down.